Good day, everyone. I hope you guys are doing well. Welcome for another video discussion. And for today's lesson, we will talk about the trademarks, copyrights, patents and trade secrets, also creating and protecting trademarks, investigating franchise opportunities, and intellectual properties in franchising. Before we start, let me introduce my group mates, Miss Donabel Garcia, Miss Isabella Inyo, Mr. Justin E. Abo, Mr. James Villanueva, Mr. Lee Webster Peñaranda, and yours truly, Miss Mariel M. de Guzman. So, the first topic is trademarks. So, the topics are contains what trademark is, why trademark matters, what kind of trademarks are there, proper and improper use of trademarks. So let's start. I am Mariel de Guzman, by the way, and I am the one who will be discussing to you what is trademarks and the topics that is under the trademarks. So trademarks is a word or phrase or symbol which I represent a company's or the company's product. They distinguish the product or service of one company or organization from those competitors provide. People can register their trademarks to legally protect to their creation or to their intellectual property. Some other examples of trademarks includes acronyms like NBC and IBM and extended to the slogan, stylized font, and even colors. So, the examples of trademarks is when halimbawa po tayo ay nasa EDSA and nakakita natin yung store ng or yung building ng McDonald's, may nakalagay sa taas na M. So, madidistinguish natin siya na trademark siya ng McDonald's kasi may nakalagay na malaking letter M na kulay yellow. So, that is the examples of trademarks. Unang tingin pa lang natin dun sa letter na yon, madidistinguish na natin siya na ito yung fast food chain, kilalang fast food chain sa Pilipinas at maging sa ibang bansa. And also, Jollibee. Kapag nakita natin ang mascot na Jollibee na kulay pula, meron siyang kasamang mga kaibigan, or yung mascot na malaking Jollibee siya. Yung malaking Jollibee na naglalakad, kulay pula, madidistinguish na rin na ay si Jollibee to. Si Jollibee ay famous fast food chain restaurant din sa Pilipinas and maging sa ibang bansa is nag-extend na rin siya ng branch. So, yun yung kagandahan ng may trademarks. Madidistinguish mo kung alin yung mas mainam na fast food chain na kainan. Kasi, ay dito, yung chicken dito maganda. Ay dito, yung spaghetti dito masarap. So, mapagkukumpara mo lang parang siya based sa kanyang trademarks. Kasi, na-try mo na din yung product nila at nung product ng isa at yung product ng isa. Yun ang kagandahan ng trademarks. Isang tingin mo pa lang, ay ang pangit ng lasa ng spaghetti dito, ay ang pangit ng lasa ng fries dito. So, that is also one of the biggest disadvantage of trademarks kasi ang daming magsa-side comments na ay wag ka dito kasi alam ko na yan, napuntahan ko na yan. So, and also kapag naman luxury brands, madidistinguish natin halimbawa is Chanel, yung dalawang magka-C na magkatalikod, that is their trade logo, Chanel. And also yung Polo brand, yung meron dito sa gilid, or yung Lacoste na crocodile, yun yung trade logo nila. Or yung Pen Shop or yung Nike na may check, that is also their trademarks. So, nadi-distinguish siya sa mga products na same or halimbawa yung ibang brand na nagsesell din ng damit And that is one of the biggest advantage, like I said, ng trademarks. So, why does trademark matters? So, trademark matters for the reason that it allows customer to recognize the product in a crowded market. And they keep the next person from copying, infringing on someone else's work. So, halimbawa, yung Nike, 'di ba check siya dito sa bandang right side. Pag binaligtad mo siya sa left side, ibig sabihin kinopy mo na yung trade logo ng Nike, which is yung check. And also, kapag halimbawa is kinopy mo rin yung phrase ng Nike, which is just do it, you do like just do that. So that is one of the biggest advantage if you file a legal protection from your trademarks. Napoprotektahan ito na makopy ng ibang tao para magamit sa kanilang business or magamit pa ito sa iba pang purpose. So, customers then identify it with brand value and offering to expect. So, like I said, kapag luxury brands, nag-expect na yung tao na it is high quality and iba siya dun sa mga local products, iba siya dun sa products from abroad, from Japan, from US, from Canada, from England. So, yun ang kaibahan or kagandahan ng trademarks. Nag-e-expect na yung mga tao na high quality talaga kasi from the brand itself at from the trusted trademarks or trusted products. So, that is why trademarks matters. So, according to David Hay, brand valuation points out that the single largest source of intangible value in a company is its trademarks. So today, Google is the most valuable trademarks on the planet, which have $44 billion, and companies like Apple, Microsoft, and IBM offer high-quality products and services that aren't available elsewhere. So, ang pinakamagandang nagbibigay sa atin ng serbisyo and high quality talaga ng information ay si Google. And also, yung companies like Microsoft, they are the one who has the higher value of trademarks around the globe. Their trademark is allows the customer to differentiate them from other company with a similar offering. Competition ensures that companies strive to create the best of products and service in a marketplace and accordingly into the public benefits. So, what kind of trademarks are there? There are many different types of trademark. They can be combined in various ways to align with the personality of the look of the brand, and the types of trademarks includes brand names. So, kapag sinabi natin brand names, ang pumapasok sa isip natin, brand ng cellphone, iPhone. Brand fast food chain, McDonald's, Dolce and Dolce Gabbana. So, kapag product names naman, iPad or Big Mac. Or yung Jolly Spaghetti. Or kapag sa shoes, Nike Air. Tapos kapag slogans like Capital One's What's in Your Wallet and McDonald's, I'm loving it. Kapag Jollibee, bida ang saya. Kapag BDO, we find ways. Kapag yung mga service, ganon, sa mga services, makikita mo. Kapag sa mga, halimbawa is, tindahan ng manok, masarap kahit walang sarsa. or masarap kahit walang sauce. Chokes tugo yun. So, halimbawa naman is word in stylist or in font is Coca-Cola. Makikita mo pa lang sa pagkakasulat ng Coca-Cola lunch siya. So, madidistinguish mo siya na, ay, ito yung ng Coca-Cola, sulat. And also, kapag colors like National Breast Cancer on foundation, or it should be pink. And also, kapag product shape like Coca-Cola bottles and AirPods, kapag Coca-Cola bottles, makikita mo naman yun or makadi-differentiate mo yun sa ibang brand or sa ibang soft drinks. Symbols, also known as device, like the Nike swoosh, shoes, are symbols and Mercedes emblems. The combination, also known as composites, marks includes more than one features like Starbucks coffee or Starbucks itself, yung babaeng mahaba ang buhok, or tapos yung signature ng Starbucks, which is their cup. So that is the different types or different kinds of trademarks. So the proper and improper use of trademark is the next. So there are guidelines on using trademarks properly. The idea is not to alter the registered name itself. For example, don't make trademarks plural or make it possessive by adding an S unless it is already been there. For example, to write Oreos is incorrect. It should be Oreo cookies. So, also, Jack Daniels includes an S in the names, where areas Levi or Levi jeans does not have S in the last two alphabets in the And also, trademark should be adjectives, not a nouns. It is not, example is Legos. It should be, but rather be Lego, a toy blocks. A trademark should not be also used as a verb. One cannot use Xerox something, but rather they use photocopy. It is also important to distinguish a trademark in text by using all caps, making it bold in italic, underlining, or using quotation marks, and of course, if it's registered, the registered symbol should be included. So that is the proper and improper use of trademark. So the next topic under trademarks is the trademark status. So what is trademark status? There are different symbols to indicate trademark status, like TM for trademark, SM for service mark, and an encircle R for registered. They will appear as subscribes after the item they are protecting. The trademark subscribe is usually used as an unregistered trademark to protect a word, phrase, or logo from their potential user. TM symbol does not, however, ensure that it is protected under trademark law. The symbol SM protects service rather than product. Similarly, use of SM symbol does not ensure that it is protected under a trademark law. Legal protection is guaranteed with the registered R with circle beside. This requires registration through the USTPO, and it is highly recommended to have a trademark attorney assist you with the process of these trademarks. So overall, if you are going to formulate trademarks, trade logos, trade phrases, you need to go to your local government for it to be legalized and for it to be not to use by those potential users or your competitors, so that it will be only yours and it will last until there are different trademark status. There are different symbols to indicate trademark status, like TM for trademarks, SM for service mark, and an encircle R for registered. They will appear as subscribed for after an item they are protecting. The trademark subscribe is usually used for unregistered trademark to protect a word, phrase, or from other potential users. The use of TM symbol does not, however, ensure that it will be protected under trademark law. The symbol SM also protects service rather than product, and similarly to TM, SM does not ensure that it is protected under trademark law. Legal protection is guaranteed with the registered R or encircled R. This requires registration through USTPO, and it is highly recommended to have a trademark attorney to assist you with this process. So if you are planning to have a trademark logo, trademark phrases, etc., you need to undergo legal process for it to become legalized. So wag po nating hayaang magamit ng iba yung pinaghirapan nating creation, at dapat po is sa atin lang yon, solely for our own accord, solely for our own purpose, and we should practice to undergo legal process for every transaction we will going to face in the near future. So the next topics is copyrights, which will be discussed by Ms. Donabel Garcia.
Hello, my name is Donabel Garcia. So, what is copyright? Copyright is a legal term of describing ownership of control of the rights to the use and distribution of certain works of creative expression, including books, videos, pictures, musical composition, and computer programs. Who is copyright owner? Copyright holder is often a company or a corporation. If a work are created as a component employment, work for hire, then the copyright or work defaults to the employer. Based on my research, there are the exceptions to copyright, which is the product names, title of works such as a book titles, name of organization and business, and the list of ingredients such as the product labels. Not every expression of an idea or may be copyright protected, but something of this list are such as a name of product, title of works, name of organization and business, or may be afforded protection under the trademark laws. So, how do copyright works? Copyright protected of an original work of authorship, including of this list. It prevents from other copying or otherwise exploiting the copyrighted content without copyright holder's permission. When someone creates a product that is viewed as an original and that requires significant mental activity to create, this product becomes an intellectual property that must be protected from unauthorized duplication. A work is automatically protected of copyright from the time it is complete. The author of the work can claim the copyright protection by adding the copyright symbol, like this, or the name of the copyright and their names and the year of the work was created. In the other words, one of the safe that can be used to legally protected an original creation is the copyright. So, this is my report ends, and my next member will follow. Thank you.
Hello everyone, my name is Maria Isabel Villaina from BSPA 3B major in marketing. So I will discuss the patent and trade secrets. So the first one is patent. What is patent? Patents are used to protect the way things work. A patent is a right created for an innovation that is new and useful. So, for the duration of the patent, the owner of the invention has the sole right in to commercialize it, and the owner can also silence others to create, use, or sell the innovation or product made with it. And the patient's protection is not automatic, unlike copyright protection. It is necessary to file a formal patent application, and it is also necessary to keep the innovation secrets. The second one is trade secret. So what is the trade secret? A trade secret is any practice or process of a company that is generally not known outside of the company. So information consider the trade secrets give the company a competitive advantage over its competitor, and it is often a product of internal research and development. Then, a cooperation must make a reasonable attempt to keep the knowledge hidden from the public in order for it to be declared a trade secret in the United States. And the secret must have intrinsic economic value, and the trade secret must contain information. A company intellectual the property include trade secret. Trade secret, unlike the patient, is not known to the general public. So the different patent and trade secret is patent is can protect invention, innovation, and the trade secret can do the same things, but trade secret can also protect the information like data, client list, and software, things that are able to be kept as a trade secret.
Good day everyone, I am Justin Abo. I am here to refer to given topic by my groupmates, and it's all about creating and protecting trademarks. First, what is trademarks? We all recognize the companies easily because of a unique word, logo, or device entries. These are called marks. Trademarks that indicate the origin of the goods or services. They helps the companies to express their individual values and to increase their recognition and be easily identifiable. To consumers like us, over time these unique marks and logos becomes associated with the company and its product, just like iconic symbol of Mercedes remind us of the Mercedes cars. These marks thus signify and certain quality and the unique. properties, and benefits provided by the product or services sold under the marks. A trademark therefore includes a word design, logo, letter, numeral, logo colors, combination signature, or any sign or symbol, which when used on a product indicates the company as their origin and guarantees certain quality of the product. Offered by the company trademarks the consumer to make and inform a good product. A company or a person can apply to protection of its trademarks at the respective trademarks registry if the marks meets all the requirements for a trademarks. The trademarks registry grants a registration certificate to the applicants. After this, only the owner of the trademarks has the exclusive right to use the registered mark on their product, service, etc. Trademarks rights can be therefore be acquired by the registration or used to in additional to protection, and trademarks like any assets can be monetized, that is, it can be licensed to another for use. Based on a great terms and condition example, Mercedes can use the unique shape logo, and only Air India can use the unique Maharas image unless someone else is using them under the license with permission for Mercedes or Air. But if it is used in somebody, trademark once rights acquired over a mark through registration or use, no one can use the mark without a license or permission from the owner of the trademarks. This is the 7 sample of creating and protecting trademark. First, unique sign. The companies often use unique sign, symbol, letter, sounds, slogan, etc. Second, source of origin. A trademark is an indicator of origin of source of the goods or services and helps consumer relate the trademark's owner. Third, exclusive rights. Trademarks rights are exclusive to trademark owner. Use of the same by anyone else for identical or similar goods is a violation of a rights. Next, number 4. Trademarks infringement is an offense. Trademarks owner offense. Some people make fake goods by using other popular companies' logos and symbols to trick consumers. 5. Fake goods are harmful. Fake goods may seem like a bargain, but they can be dangerous and also could be funding organized crime. Number 6. Fake goods harm society. They receive poor quality goods at an excessive price and are sometimes exposed to health and safety danger. And last, number 7. Always buy original. Considering that original product have a better quality and can be used for a longer time, people usually buy original product for their collection. And that's all. Thank you.
Good day, I'm Lee Webster Piñaranda, and I'm the one who will discuss the intellectual property right. Intellectual property rights are the rights given to persons over the creation of their minds. They usually give the creator an exclusive rights over the use of her creations for a certain period of time. The intellectual property involved in such case includes use of trademarks, trades, and business secret, patents, and patented phrases, inventions, copyright, and other creations of mine, which are owned by the franchisor. Franchising is attractive to franchisees because they can invest in an established brand in which goodwill is already attached to a greater or lesser extent, depending on the market. This of course means that it will be easier to attract business since the reputation of the business has already been established by the franchisors and create a far better sellable. Trademarks in particular are an essential part of a franchise because they can indicate the source of the goods and or service and communicate the source of consumers. The brand is instantly recognizable to consumers and immediately communicates to the consumer the nature of the quality of the service and or goods they can expect to receive from the franchise.
Hi, I am James Villanueva, and I am going to discuss the investigating franchise opportunities to all of you. Before we talk process, however, it is important to understand that investigating potential franchise opportunity is often a process of elimination. Also, investigating franchise opportunities has its 6 primary steps. Number 1. Reach out for general information. Kick things off over the phone or through the company's online form if they offer one. Franchisors should give you a general overview of the company and typically have informational resources available in some form. Number 2. The Franchise Disclosure Document. The Franchise Disclosure Document or FDD is an FTC-mandated document franchisors are required to hand out to potential buyers. In truth, it's more than a book than a document. Inside, you'll find a wealth of information about the company you should carefully examine and consider. Number 3, evaluate the franchisor. Once you have the information at your fingertips, it's time to dive deep and carefully examine every aspect of the business before making any kind of decision. Number 4, talking to franchisees. Also called validation, it's more important to ask questions of current franchisees as well as the franchisor itself. In addition to picking up the phone, you should seriously consider visiting as many locations as possible to meet with the franchisees in person. Number 5, meet the franchisor at Discovery Day. Usually called Discovery Day or something similar. You'll want to meet with the corporate team in person at their headquarters. Usually, this will be an event scheduled and planned by the franchisor. Number 6, make a decision. Once you're satisfied you'll have all the information you need, it's time to make a decision.